Berger. I'm a pediatrician at Children's Hospital of Pittsburgh.
Bill Strickland, as President and CEO of Manchester Bidwell Corporation in Pittsburgh, a training center.
Delilah Rumberg, CEO, Pennsylvania Coalition Against Rape, National Sexual Violence Resource Center.
Bev Mackrith, Deputy Secretary for the Office of Children, Youth, and Families at DPW.
Sorry about that. Dr. Cindy Christian. I am a pediatrician at the Children's Hospital of Philadelphia, at the University of Pennsylvania, and the medical director for the Department of Human Services in Philadelphia. Good morning, everybody.
Good morning. I'm Jason Kudalakis. I'm in private practice with Ablom and Kudalakis in Carlisle. By way of history, I was the past president of the Pennsylvania Children Youth Solicitors Association. Those are the lawyers that represent the child welfare agencies across the state.
Hello, my name is Jackie Bernard. I'm a prosecutor from Blair County.
Good morning. I'm Gary Ipock. I'm the executive director of the Glen Mills Schools in Glen Mills, Pennsylvania.
Good morning. My name is Carol Pachado, and I am a social service manager with the Department of Human Services.
Tim, who is the remaining member of our panel, is let us know that he's on his way, but he can't. We have a distinguished group of presenters this morning, and our first is Dr. Richard Gellis. He is the Dean and occupies the Joanne and Raymond Welsh Chair of Child Welfare and Family Violence and is the Dean of the School of Social Work and Practice at the University of Pennsylvania. Dean, if you would step forward and take a seat, make sure that you press the confounded button so that your words will be memorialized.
Green is good. Thank you. Thank you, Judge Heckler. I'm honored to be here this morning, and as is my pattern, what I've done today is provided written testimony, but I'm sure you don't want to hear me read from it, and I certainly don't want to hear myself read from it. So Judge Heckler heard me speak a few months ago. He asked me to essentially do what I did a few months ago, and I'll try to recreate that. What I did for the Bar Association in Philadelphia is provide context to Child Protective Services and most especially Child Protective legislation at the state level. I was having dinner last week with my neighbor who is a neurologist. He's currently the president of Jefferson Medical University and is on his way to become president of Rutgers University, and we were talking about Child Protective Services, and I said, you know, Child Protective Services is not brain surgery. It's vastly more difficult than anything you've ever attempted. The key difference is that when a doctor conducts brain surgery, it's pretty clear that the object is to repair the brain and keep the body intact. The object, well, not the object, but brain surgeons never have to make a choice between, well, we'll save the brain, but we're going to lose the body, or we'll save the body, but we're going to lose the brain. But in child welfare work, it is the nature of the law and the nature of the practice that there are three goals for children and families who come into the system, and realistically, they're frequently incompatible. We can choose to keep families together. We can choose to assure the safety and well-being of children, which is what the federal statute calls for. And we can aim for permanence of caregiving for children by caring and loving and available parents. We can't necessarily do all three. Sometimes preserving the family puts the safety and well-being of children at risk. Assuring the safety and well-being of children frequently requires making the choice of taking the children away from the family and terminating parental rights. And there are various forms of permanence that children can achieve. And while we may believe that children raised by their birth parents is the optimal permanence choice, it can't be achieved for many children who come into the child welfare system. The brain is the same, last time we checked, in all 50 states in the District of Columbia. But child abuse laws differ in every one of the 50 states in the District of Columbia. And the instrument of delivering the law differs by the 300 different jurisdictions in which Child Protective Services is carried out in the United States. And to put not too fine a point on this particular argument, brain surgeons have at least a decade of training. They have the latest technology, and they have stood by for many years and watched brain surgery be conducted before they are allowed to use a scalpel. Those of you who work in the child welfare system understand that the instrument of child welfare service delivery is, in the best of times, someone with a master's degree, but frequently someone with a bachelor's degree in the liberal arts, and their job tenure tends to be 3 to 5 years. Modern technology in the child welfare system has evolved into a cell phone, and if you work for a very well-funded system, you might even get your own laptop. That, by brain surgery standards, is essentially the quill pen version of technology. Now, I have watched this system evolve for 40 years. It was purely by chance that I found myself in Washington to observe the Senate hearings that led to the Child Abuse Prevention and Treatment Act in 1974, which mandated, to a certain extent, all states to have mandatory reporting laws. And I think it's important to understand that when we drafted and when we implemented and when we advocated for mandatory reporting laws, this is the world we understood. The largest estimates of child abuse and neglect in 1974 were that there might be between 50 and 150,000 children in the United States who are being abused by their caregivers. The number of reports that had been received prior to mandated reporting, David Gill counted to be something in the vicinity of 7,000. So the gap we were talking about was, we know that there are 7,000 cases that come to our attention. The assumption is, well, we might see as many as 50,000 to 150,000 cases. No one in 1974 imagined that by 2010 you would have 3 million reports involving some 5 million children. How did that happen? Well, be careful of what you wish for. When we made child maltreatment move from a private trouble to a public issue to a social problem, we did add technology. The technology was highly advanced for the time. It was called Wide Area Telephone Service, or WATS lines, which now known as toll-free lines, which are almost meaningless to my children because they had unlimited service on their cell phones. So that my children's generation, and when I talk about children, they're in their mid-30s, they can't imagine not making a telephone call because there would be a specific charge of $2 or $3 for making a call from Harrisburg to Philadelphia. So the technology changed, public awareness campaigns changed, and of course in 1974, most states adopted mandatory reporting laws. Second thing occurred. When we were sitting down in 1974, we were working off of a definition of child abuse that primarily looked at the physical abuse of children. Neglect was understood to put children at risk, but it was not showing up and it was not being studied in with any great effort, and child sexual abuse wasn't even discussed. It certainly was put into the law, but if you look at the record of the hearing in 1974, no one came in, no one mentioned the possibility that caregivers could sexually abuse children. The definition has gradually expanded well beyond what we were thinking of when the idea of mandatory reporting was hatched in the late 60s and 1970s. Then following that, there was a belief, and I don't think any of us ever wrote it down. I think today was probably only the second or third time I ever wrote it down in actual black and white. But there was definitely an advocacy component of mandatory reporting. And the advocacy component of mandatory reporting was, if you're old enough to remember this, when the bill passed, Richard Nixon was president. And Nixon had just vetoed the Comprehensive Child Development Bill that had been drafted by Ed Ziegler, now at Yale University. And so the Democrats who were in control of the House and Senate were trying to come up with a bill that would benefit children that, quote unquote, even Richard Nixon won't veto. And Walter Mondale said at the time, there's no way that Richard Nixon will veto a bill that deals with abused children. And he was right. And in fact, the Nixon administration put significant resources into the effort to combat, prevent, and treat child abuse and neglect. But the resources were always less than what the advocates wanted. And so the advocates understood from day one that if you get a large number of reports of child abuse and neglect, you can successfully bid for scarce public resources to fund state, local, and community efforts to prevent and treat child abuse. There was always the not public expressed belief that if we could make the problem big enough, we would be able to compete successfully for government funding. It didn't work. Government funding never kept pace with the number of child abuse reports. And then in 1980, there was a sea change. Ronald Reagan became president. And when Reagan became president, ketchup became a vegetable. That's a sound point, a sound bite for explaining that there was a major ratcheting back of government funding for social programs. It was at that point, again, something that we don't write about often, that the Child Protective Service community had to make a moral choice. Since the normal means testing for getting government services was being pulled back, the child maltreatment field embraced the notion that it would be okay to use child abuse as a means test to get daycare, housing, heating, food stamps into the hands of needy families. We overlooked and sidestepped the problem of, do you think families really will accept the stigma of being labeled a child abuser as a trade-off for getting services? And as it turns out, 22 years later, the answer was no. Families don't want to be labeled child abusers. They don't believe that that's an acceptable trade-off. And using the child welfare system as a very open and porous gate to provide social services to families has not turned out to be a particular success. What has in fact happened is that reporting expanded from hundreds of thousands to millions, and the system was never able to keep up with it. And so what happened in the system nationwide is, as reports hit 1 million, the substantiation rate began to drop. And I'm going to assume I don't have to explain to this group at this point what substantiation is. But substantiation's dropped from the 50% to the 40% to the high 20%. And now, given the variations across the 50 states, in fact, in Child Maltreatment 210, of the 5 million reports, 5 million children, 3 million reports, 2 million investigations, substantiated cases actually totaled 440,000, about 19%. All of the money that is used to conduct a child abuse investigation, 95, 99%, is state and local taxpayer dollars. Federal government's funding for investigations is a very small amount of money that comes to states through the captive block grant. So states have absorbed one could argue that mandatory reporting is another federal unfunded mandate. Now, there is funding, but it's very small. I don't say it in my written testimony, but I think it's worth pointing out that we have now, in the 40th year of this great experiment, and here's what we don't know. We don't know whether mandatory reporting has improved the safety and well-being and the protection of children in the United States. We don't know whether at a certain point mandated reporters stop reporting because 8 times out of 10 nothing actually happens. So we don't really know whether this experiment has been valuable. There is, certainly since October, a great deal of discussion in Pennsylvania about should we expand who reporters are? Should we invoke punishments for people not reporting? And the metaphor I use in my written testimony is, do you really want these systems to have to drink from a fire hose? They've not demonstrated the ability to drink from a fire hose and offer protection to children in other states. There isn't any particular reason to think that adopting it in Pennsylvania will, and I'm guilty of burying my lead, but what I would like and what I would hope this task force is able to do is keep on message, and that is that you exist to improve the protection of children in the Commonwealth. And so that everything you do and every decision you have to make and every piece of testimony you hear ought to be measured against, will this improve the protection of children in the Commonwealth? Personally, I don't think that requiring your counties, and particularly your big counties, to drink from a fire hose in which you've turned up the flow and the pressure will make their jobs any easier. In fact, I think it will make their jobs much harder. It's important to look at the child welfare system realistically. I think if you look at the mission statements and the law, sometimes you get the impression that child welfare systems exist to deliver services to vulnerable children and to needy families. But the reality, and I'm reminded of this because I'm supposed to cover this according to the little yellow sheet I have, the reality is the child welfare system exists primarily to make decisions. And it makes decisions through a series of legally structured gates. Gate A, not Gate 1, Gate A exists outside of the system. And that gate is an individual's decision whether to report a case of suspected abuse and neglect. The first gate of the system is the screening gate. The second gate of the system is the investigatory gate. The third gate of the system is the action gate. Do we substantiate? Do we indicate? Do we close? The subpart of that gate is, if we keep the gate open and we substantiate the case, do we leave the child in the home or do we take the child out? In my testimony, I show the kind of pyramid of child abuse and neglect gates that begins with 3 million reports and 5 million children and ends up with essentially nationally 200,000 children receiving services. Half of those children receive services mandated by the local Child Protective Service Agency, but are allowed to stay in their own home. The other 120,000 children are placed in foster care. So there's a great many steps that take place and a goodly number of decisions that take place before the service arm of the system is even activated. And it's important to understand that in decision making, with every decision you make, 3 things can happen and 2 of them are bad. The good news is you can look at a case, decide the child should be removed, or look at a case and decide this is not abuse and neglect, or look at a case and believe that you can provide services in the home and the child will continue to be safe. And that's the good news. But bad thing number one is you can look at a case and say, this child is unsafe, this family is unsafe, they're not going to change, I need to take this child out, when in fact that family would have embraced services, that crisis would have passed, and you could have bypassed the whole foster care system and left the child in the home. That's what we would call in statistics a false positive. The third thing that can happen is a false negative. We're just going through one of those in Philadelphia. And hindsight being what it is, everybody, including my wife, thinks that was an easy call, the Khalil case. And I say that wasn't an easy call at all. They made a series of decisions, something really awful happened. They decided that the family would embrace services, even if the other children had been removed. They decided that a family that was going to produce clean urines for 3 months had engaged in services. And unfortunately, for a variety of reasons which still remain within the walls of DHS, the decisions that were made at the various gates turned out to be false negatives, and the child, in fact, turned out to be a mortality. The law can't do much about this. Your task force can't do much about this. But you need to understand that the Child Protective Service workers who are making these decisions in the Commonwealth of Pennsylvania are using the weakest possible criterion upon which to make those decisions. They're using clinical judgment. And there's 30 years of research in social work, in psychology, in decision-making in the Wharton School that comes down always on the same side of the evidence. Clinical judgment isn't a whole lot better than flipping a coin. Now, I think the Commonwealth has been appropriately cautious. Beverly's looking at me wondering what I'm going to say next. There are states that have embraced probabilistic decision-making. Our neighboring state, New Jersey, is using structured decision-making. The Commonwealth has looked at that and said, you know, the evidence isn't that compelling, that structured decision-making is so much more accurate than what we're doing now that we want to put all of our counties through the exercise of making this kind of sea change in decision-making. But the time is going to come sooner than later that the science and technology will require us to do that. We are close. In this decade, we will be able to have technology such that decisions can be made with far greater precision than we're making now. You need to anticipate that, because the law, this is your window. Generally, we don't change laws but once a decade. So in changing the statutes in the Commonwealth in 2012, you have to look into the future and say, there will be workers who will have little tablets that will be able to access data sets, that they will be able to input data, and it will give them in real time a pretty good indicator of just how much risk this child is under, of just how much safety exists in this home, of whether it is appropriate to remove a child from the home or leave the child there. The part of the introduction I left out that I put in the written testimony is that I've done a fair amount of expert witness work, usually for plaintiffs, sometimes for defendants. It's given me the opportunity to read dozens of cases in the Commonwealth, in New Jersey, in 6 or 7 other states. It's given me the opportunity to go back and look at, with not great ease, by the way, the various titles that exist in the Commonwealth that cover the definition of child abuse and neglect, that cover the reporting statute, that cover who has to make a report, that covers under what circumstances people make the report. And if you haven't been in litigation, you don't know, but Cindy and I certainly know, and probably Rachel knows, that the standard of care for Child Protective Service work begins with the state statutes. So in a court of law, if you were going to successfully sue the Commonwealth or the City of Philadelphia, you have to prove that the caseworkers, the supervisors, the agency violated the standard of care willfully while knowing what it was. So I've had to really look very carefully at our standard of care, and I see three problems. Problem number one. As good as an idea as it seemed, setting the bar, and I'm from Massachusetts, which means you really do have to spell that out in Pennsylvania. So that would be B-A-R, not B-A-H-H-H, the way we spell it in Boston. Setting the bar as high as we've done by having it keyed to intentionality and serious injury seemed like a good idea. It seems like a good idea because it doesn't require the local districts to have to drink from the fire hose. Only really serious cases should come to their attention. My colleague David Gill, back in 1974, when he testified before the United States Senate, talked about intentionality and severity of injury. And at the time, David still has twin boys, but at that time he could actually hold them in both hands. I think they were both 3 at the time. And David said very poignantly, if I take my twin sons, pick them up and throw them to the ground, and one lands on concrete and fractures his skull, and the other lands on the carpet, bounces up and runs away, are you planning on charging my right hand with child abuse and my left hand with just being an inappropriate parent? Because you're measuring me by outcome. And outcome is oftentimes random. Outcome isn't tied to the intentionality. Outcome is somebody's in the wrong place at the wrong time. And by keying our law to severity, we are in fact compromising whether we can protect children. I also think there's another problem, and that is I don't think most reporters read the law. Certainly none of the ones I've ever interviewed read the law, which means they're operating off a completely different mindset. They don't sit down and read Chapter 23 and say, aha, this child, Chapter 23, this is what I should do. They look at a child and see a child in crisis. And they make a report in good faith, and then they sit there wondering why 8 out of 10 times, or in the case of teachers, 95 times out of 100, their report is not substantiated. So I would take a very careful look at that, because I think that while it may have been well-intended, it does not offer the kind of protection to children in the Commonwealth that this task force would want to provide. I think the second aspect of the law that caught my attention, and I have to admit it caught my attention because of the Penn State allegation, is Pennsylvania's carve-out of what constitutes a perpetrator. And so in the language of the law, and I will read this in case it is not immediately available, in 23 paragraph 6303, a person who has committed child abuse and is a parent of a child, a person responsible for the welfare of a child, an individual residing in the same house as a child, or a paramour of the child's parent. That's the definition of a perpetrator. That works almost all the time, except in sex abuse. So in a variety of cases in the Commonwealth in sex abuse, the cases have gone to the criminal justice system because the offender was not offender under Pennsylvania statute. And the criminal justice system does a very different investigation. They're looking to investigate a crime. They don't necessarily always call in Child Protective Services. They don't necessarily look to protect other children in the home. They look as to whether or not there is a significant evidence to bring a criminal charge against this offender, against this child. Across the Delaware and New Jersey, their definition of child sexual abuse is a sexual penetration of a person over the age of 13 and under the age of 16 by one who is 5 years or more older than the victim constitutes sexual abuse. Now, they do have a different part of the statute that deals with kids under the age of 13. But as you well know, in the case that may have led to us all being here, there's some ambiguity over whether or not there's no ambiguity about whether it's a crime, but there's significant ambiguity over what was reportable to Center County Child and Youth Services. If it had occurred in New Jersey, there would be no ambiguity whatsoever. It is, by statute, child sexual abuse, and I think they are, in the cases I've been involved in, I think they are on the right track. I want to come back to the surprise I had when I was preparing the testimony. The Department of Public Welfare has published a wonderful book, Child Maltreatment. Let me give you the exact citation. It's actually more comprehensive than what the feds have. Pennsylvania Department of Public Welfare 2010 Annual Child Abuse and Neglect Report, published by our Department of Public Welfare. And so it does what the feds don't do. It gives us a breakdown of who makes the reports in Pennsylvania and what percentage of those reports are substantiated after investigation. Here's the surprise. One of the largest group of reporters nationally are educational personnel. They make 16.9% of the reports nationally. In Pennsylvania, of the 24,000 reports, 6,900 were made by educational personnel, by school personnel. Of the 6,921, 5.6% were substantiated. Now, the overall substantiation rate is 14.9%. The substantiation rate for anonymous reporters, people who have no clue who they are, they just call it in. They could be a vengeful spouse or a vengeful neighbor or a concerned citizen. We have no idea. Their substantiation rate is 5.1%. And I looked at that and I said, that just somehow doesn't add up to me. You've got school personnel making all of those reports, but only 5.6% is substantiated. Where's the kink in the hose? What's getting in the way of this? Well, a variety of logical, plausible hypotheses, not the least of which is school personnel don't read the law. They're not trained in the law, and they're responding to a dirty child, an ill-clothed child, a poorly fed child, and they're reporting a crisis, which is going to end up as a GPS report, not a CPS report. And so that's one explanation for the low substantiation rate. But you have to consider the other plausible hypothesis, and that is the unusual carve-out that Pennsylvania has in terms of institutional reporting. So you know, and I'm sure by now you know that our law says that school teachers aren't obligated to make the report themselves. They report it to a school CEO or a designated official. What I know about forensics and what I know about child maltreatment is the further away the report gets from the person who has the most primary first-hand information, the more difficult it is to put the pieces together and do an appropriate screening, let alone an investigation. So Cindy and I, from day one, have argued about this. But I see no problem with dual reporting, but I can tell you that my social work students who go out into the field and work in schools, one of the problems they bring back to me year in and year out is, I'm exasperated. I see a child in school, that child conforms to the definition of child abuse and neglect that exists in the law. I reported it to the appropriate school official and they haven't done anything about it, and I can't do anything. And I say it's a kink in the hose that's created by our legislature, and at one point or another, I hope the legislature goes back and looks at that and says, are we really doing the right thing? Again, not measured against practicality, measured against, does this appropriately protect children? So I thank you for indulging me. I hope you take a look at the testimony. It has a little bit more in the way of research behind it. And Cindy tells me that you all ask very penetrating questions, so I'll sit back and let you have at me.
Yes. Should we start at the left? Ms. Hobbs-Picciotto?
I definitely enjoyed your presentation. You were very candid and at the same time sensitive to all parties involved. And I really don't have any questions at this time, but it was enjoyable. Thank you.
Thank you, Doctor. I don't have any questions myself. Thank you.
Doctor, while serious, I found your presentation and testimony to be refreshing and enlightening, and I greatly appreciate the time you've taken to put these comprehensive thoughts together, and I think it really gives me some ideas and some things that we need to do. Just on the last point you were making, as it relates to school reporting and the concept of dual reporting, can you just elaborate more on that? As I understand, schools are also required under many different statutes, including Title IX and various different things, to make sure that there is a designee at the school that receives a report. So are you suggesting there should be a requirement that that dual report goes to that designee for whatever purpose, as well as to Childline or the county welfare agency?
First, I think it's important to understand that even in the months after the events at Penn State, that it would be fair to say that in my experience, most universities and colleges in the Commonwealth have yet to identify and publicly announce appropriately who their designee is. They're still unwinding their policies and communicating. I know that in the cases that I've been involved in at secondary schools that have involved sexual abuse, all the training that takes place is after the fact. The teachers, the counselors, the janitors have no idea who the designated individual is, even though the statute is there. So that hasn't done well. We haven't done well by that part of the statute. But in my conversations with Cindy and as my function as a dean of a school who says to his staff, please don't surprise me, please never surprise me, I would think that on our team, if we're under the Clery Act, and they've been bumping up the pressure under the Clery Act under Title IX to report sexual assault and sexual harassment, I would expect that someone on our team who's going to report it to the university official would also let me know simultaneously. There's just good organizational practice. If you have to put it into law to make it work, put it into law to make it work. But this system now of reporting it to the designated person who hasn't been designated and we haven't trained about and who may change ends up with one of these deals going on. So I just plain don't think it's going to work.
Hello, Dean Gellis. Thank you very much for those enlightening comments. And I would like to put on the record that in our discussions about kind of the systems in the school, what I'm opposed to, I believe, is a system where, or a recommendation where everybody in an institution or everybody who has knowledge about a potential child abuse case has a mandate to report that, because in a school, not everybody in the school might know firsthand about it, but in a hospital setting, you have a child who's seen by 12 people in an emergency department and 5 different subspecialists and nurses in the ICU and then more nurses and doctors on the floor, and then you have a system where a hotline is getting 74 reports about a suspected child abuse case. So I do believe that a primary person who has a responsibility, we need to figure out a way that ensures that that report gets made, that ensures that. But again, I just think it's in part a little bit of a numbers problem. And then you did answer, I think, my question about why you think the rates of substantiation are so low when teachers report. And I get the sense that it's because of a dilution, almost a dilutional effect. By the time it gets to the person who's going to make the report, it's like hardly a report anymore, and they don't really have any valid information.
It could be, and again, it could be the teachers, counselors are seeing a lot of neglect. That it's rare that, let's, look at some of the cases you and I know about. If a child has been badly injured and has a hand mark on the side of the child's face, the parents will keep the child home from school until it heals. If the child has a black eye, the parents will keep the child home from school until it heals. But a neglected child, no, they won't do that. And so the schools are going to see a lot more neglect than, say, you as a physician is going to see.
Well, we do see a fair amount. And then I have one more question, if you will humor me. Because you know a lot about everything regarding child
Is that the
welfare.
part I'm supposed to humor you about?
No, my colleagues have to humor me. I have one more question. Could you talk a little bit, and you didn't really comment on this, but it's something that people keep talking about kind of peripherally, and I'd like to hear what you have to say about kind of alternative response systems and kind of what you think they really are and where they work and how they may or may not work.
So we have an alternative categorization system where we screen the cases into GPS, CPS. Florida, which is considered the leader in differential response, and they got a fair amount of funding from Annie Casey Foundation and the Jesse DuPaul Foundation, they will triage the case during screening, not for the purposes of classification, but for the purposes of who they're going to send out to do the investigation. They went so far, and I actually did research on this, they went so far as to, in 4 counties, move the investigations out of Child Protective Services into the sheriff's offices. And so the sheriff's offices were doing the triage, and they would send a deputy and a CPS type worker out on a child physical abuse case or a child sexual abuse case. They would only send the CPS worker out on a neglect case, and then the CPS worker would call a deputy if they needed to do a removal. The notion was, if we're from the government, we want families to see us here to help them, not as agents of control. So we only want to send agents of control where there's a good probability the court is going to be brought in and a removal is going to have to take place. It's just some real serious physical danger to the child, whereas neglect, we see that more as, well, we need to provide housing, we need to provide health, we need to provide this, that, and the other thing. The underlying flaw of that, of course, is bad things happen to kids who are neglected. And so the conceptual notion that you could respond to neglect with less of a heavy hand and with less social control meant that you were going to have a lot of false negatives in the neglect category. No one ever did the critical test, the randomized clinical trial, to draw the line and say, now that they've done this, children in Florida are safer and better protected than they would be in other states. So what you've got is a lot of anecdotal evidence, a lot of what we call Hawthorne effect. Anything you try new, everybody loves until it doesn't become new anymore. And many states rushing to Florida saying, Florida's got the silver bullet, we'll bring it back to our state, all of which without a single shred of data. Conceptually, I think it's okay, but I would, frankly, if I'm in the Commonwealth of Pennsylvania and I've got a county-controlled system, I might want to choose 2 of my counties to do an experiment in before I forced all my counties to do it. I think Pennsylvania is a wonderful state to do pilot programs before you rush into changing the whole state. And differential response is one of those areas where the researcher in me would say, let's try it out in a couple of counties before we adopt it as statewide policy.
Thank you.
Dean, thank you very much. So far as I'm concerned, you have delivered entirely, certainly conveyed a wonderful sense that reminds us that this is not all being invented today, and that there is a wealth of experience and broader perspective. One of the questions that arises in thinking about your testimony it caught me the first time around at the CLE as this business of the instrument through whom this we're trying to do what we do for children. A liberal arts major who's going to be at this for 3 to 5 years, and obviously that's somewhat whimsical. But is there a training component? Is there an academic, if you will, a solution or a part of a solution to be pursued here?
I think that and I've gone rounds with a variety of commissioners on this, and I think we have to be realistic about it. There are 200 schools of social work in the country that give the MSW degree. The majority of the students who come in our front doors want to be 50-minute clinicians. The majority don't come to us and say, I want to do child welfare work. The minority come to us who want to do it. So for me to sit here and say, I think the solution is to have all MSWs be the criterion of being a child welfare worker, it's not realistic. The inflection point, the tipping point, I believe that we need to focus on is supervisory training. The supervisors are the key to the whole function of this system. They know the nature of their workers, but they stay longer. They hopefully many times have a master's degree, but the master's degree that I offer at Penn and it's offered around the Commonwealth isn't specialized in child welfare work, so it's in-service work. It's kind of breaking down some of the taken-for-granted assumptions about decision-making. It's going to be a real bear to wrestle with the existing culture and get them to move from clinical decision-making, which they've done their whole lives, to a more probabilistic decision-making. There's someone in Philadelphia who said, we'll do this over my dead body, which is a great straight line that I try not to respond to. But we're going to do it. We have to do it. But it's going to take a great culture shift to get, and the supervisors have to get on board first. For me to train my MSWs in doing it and send them to work with supervisors who don't understand it is a waste of all of our time. So I've been trying to focus on supervisory training. I think that's where the key is going to be. And remember that those supervisors in 10 years are going to be your deputy commissioners and your senior management team. So they really are where I would focus my attention.
When you speak of probabilistic, I guess, gathering of data or use of data, an analogy which I encounter under the criminal system, I was a criminal judge for some years, anybody who had been, or at least a prosecutor for X number of years, you look at various factors, even in even-handedly weighing a defendant, for instance, making a bail decision. In recent years, specific instruments, licensed actually instruments, I'm trying to think of the acronym now, have come into use. And I would have actually invite people up from our prison who would have prepared this score on these self-reported various characteristics and have an experienced prosecutor and me. We would guess the scores without going through the specific questions, and we're never more than 2 off. So I'm wondering, and so my reaction was, you just do this instinctively. If you know a little bit, as you find things out about somebody, the answers appear because you've done this so many times. Are there models? Is there, you mentioned New Jersey, are there other places we should look to see how this screening device fits in?
I thought Pennsylvania is wise. I think I would sit back. New Jersey uses it. Well, a lot of the states have been put through class action lawsuits, have done it because it was part of the settlement agreement. So Washington, D.C. has done it, New Jersey has done it, Chicago pioneered it. But is it vastly better than clinical judgment? No. And what I would worry about would be DPW would put 5 to 10 years into implementing it, and in that period of time, something better is going to come along. Mm-hmm. So I wouldn't jump on this bandwagon. I'll go back. The researcher in me is just compelled to say this. So, yes, you're right with your small sample. But I guarantee you this, that if I got a group of judges and I put them in a room and I divided them up into 2, and one I said, use your clinical instincts and judge these prisoners, and the other one I said, use this instrument, those 2 percentage points you were off makes a big difference in the long run. That the group with the probabilistic risk assessment is going to do statistically so much better than the judges with their clinical instinct. Look, crime in the United States has dropped 30% since 1994, and you can trace about 50% of that decline to community policing. And community policing is nothing more than using probabilistic risk assessment to deploy your police resources and, you should pardon the expression, profiling to a certain degree where you need to be to keep a crime from taking place. We can predict, we've looked at 50,000 probationers. My colleague Dick Burke at Penn has looked at 50,000 probationers, and he can tell you which of the 50,000 are going to commit a homicide in the next 12 months, based on 10 variables. That's important information to know if you're a probation officer. We'll get there in child maltreatment, but the devil's going to be in the details. Once you know it, you still have to decide which of your options available to you you're going to avail yourself of. Mm-hmm. Once you know somebody's at risk, and you have a hard number in front of you, you still have to decide whether to leave the child in the home or not. And there's going to be a lot of other variables that are going to play into that. Look, I can tell you a mistake that was made in Philadelphia because I know how it was made. It was easy to decide to leave this little boy with his parents because they produced clean urines for 3 months. Do you know what percentage of parents in the child welfare system are able to do that? Under 20%. It's such an outlier that it was incredibly tempting to use that one variable, one instinctual variable, to make a clinical decision. Turned out bad. Why? Because we didn't look at the other 10. One of which was, I know I'm going to get somebody outraged about this, homeschooling with no monitoring. That's a red flag. Mm-hmm. That wasn't factored into the decision making. If you had a probabilistic instrument, it would have been there. You couldn't have skipped the box. You would have had to enter the data into the tablet.
Thank you. It's good I'm not considering bail reduction applications anymore. I'm suitably chastened. Thank you very much, Dean.
Thank you, and thank you so much for your presentation. I have so much to think about. I was trying, as we went down the line, to put it in some sense of order, and I definitely want to meet with you at another time and really talk through a lot of these. But a couple questions I have that you touched on. We've been talking a lot about the scope of our system, that we evolved from looking at safety issues to now opening the door, and we're looking at a lot of parental control issues, truancy issues. So we have a system that, in essence, I think has moved away from looking at the safety issues to look at everything because they become the gatekeeper, which you talked about, that maybe child welfare shouldn't be the gatekeeper for all issues, and has become that. Can you just talk a little bit more about what you've seen in other states, what their systems look like, and is that just a perception we've gone too far, or are we actually doing what we should be doing?
Other states will change their systems based on the latest crisis.
We do that too.
So if a state has multiple organizations that deal with children's issues and some horrible crisis exists, a legislator will propose combining them into a super agency. And then 3 years later, there'll be a crisis, And they'll say, well, the super agency is too big, it has too big of a scope, we need to divide these into separate, smaller agencies. You've got state-directed, county-operated systems, and you've got state-run county services systems. So you've got Texas, which has got central control. They don't let the counties do anything. You've got Florida with central control, but they have single point of contact in the counties. When the Child and Family Service reviews are done, and we look at their scores on safety, permanency, and preservation, there isn't any big difference. It's not about organization. The advice I would give the advice I always give new commissioners is, what are you doing? What's your goal? And you understand that you can't do it all. You can't preserve families, you can't assure safety and well-being, and you can't provide permanency for children all at the same time. If you think you can do that, you're going to fail. And in fact, anybody who says they're going to do that, we go back to the field center and I try to propose an over-under pool for how long they're going to last. And I pick 6 months. The directors who last, the Bill Bells, the Nick Scopettas, the David Saunders, know what they're in business to do. And I really, actually, I'm agnostic. As long as they pick one and say, the janitor in my building is going to know we're in the permanence business. The people who empty the ashtrays outside the building are going to know we're in the permanence business. Everybody is going to know we're in the permanence business, and those are the decisions we're going to make, and we want children to have permanence first and foremost. That agency will succeed. So will the agency that says safety, or the agency says preservation, because they have a goal, they have a metric, and they will organize themselves to achieve that. Changing the organization of the agency is what I call one of the usual suspects. Adding money, adding personnel, changing the scope of the agency, changing the commissioner, and then ultimately changing the name have in 40 years proven to have no benefit whatsoever. But having a goal and setting your metric by that goal and judging to task, that actually does produce better outcomes.
Okay. And if I may, just a couple other things. Have you seen our safety assessment?
Yeah.
And is that moving us to the structured decision-making?
No, it's what we call consensus risk assessment. It's one step up from clinical judgment. Some group of people who thought they knew what they're doing got together, decided what they thought the risk factors were, gave them numerical values, and then, of course, the caseworkers go out there, they take the risk assessment form and said, I think this is a high dangerous case, and they start backfilling it. So they put in 32, and then they make the numbers add up to 32.
And have you seen a structured decision-making tool that works?
It works better than what you have, but on the margins, not so much better that I would advise you to turn your system inside out. I mean, I can be very sardonically critical. I am sardonically critical of what you do. But I also am realistic to know I'm not advising you to change it. Maybe I would advise you to evolve and have handheld technology such that the workers are not allowed to back enter it. But on a paper system, because they can back enter it, what you're getting is clinical judgment that looks like it follows the risk assessment. I've done enough expert witness work to know that there's a real disconnect between your form and what the workers are really doing.
Yeah. And just my last question, how do we determine the effectiveness of the system that we have today? Because I've seen some national data that shows that child welfare systems end up doing more harm than good. I don't know if that's accurate or not, but shouldn't we take a look at the system that spends $1.9 billion a year? Are we doing anything? Are we doing the right things to help families and children, and are we keeping children safe?
You've got the Child and Family Service reviews. They were created by my colleague Carol Spignan when she worked at the Children's Bureau. They're built on the principles of the Adoption Safe Families Act. They're as good as anything.
Okay.
And you know what the criticism of the states is always? They set too high a bar. Well, too bad. That's the bar we're dealing with kids. There's no other child protective service system out there. If yours fails, that's it. So I would use those. I think that the percentage of children who stay in foster care more than 5 years should go down. The number of months children stay in foster care should go down. The proportion of judges who allow aggravated circumstances to bypass reasonable efforts should go up. I think it's totally underused. I think you should hold your county's feet to the fire on the 15-22-month rule. In Philadelphia County, they're allowed to basically bypass what the federal law requires, which is to provide written justification for not following the 15-22-month rule. That's your biggest system, and they're not providing written justification that's in the best interest of a child. Why we're not terminating after the child has been in care for 15 of the previous 2 months. There's a consensus we don't have to do it as long as it's orally stated in court. Well, yeah, except we wrote the law in 1997 and said specifically in the law there has to be written request for that bypass. So there's lots of moving parts you can twink to hold people accountable. The one thing you can't control, the one thing nobody can control really, fatalities in the child welfare system. They haven't budged in 20 years. What you'd like to see is fewer children die who've had family contact with your systems. But overall, nothing we've done nationally has budged the homicide rate of women who are victims of domestic violence, and nothing we've done has budged the number of children who've been victims of child abuse fatalities. So I would not keep that as a key metric. But the other things, as my colleague will tell you, they're changeable, they're movable. You can do something about those.
Thank you very much.
Yes, and the chairman and Bev both asked the questions. I was really going to probe about the models for the structured decision-making, and because I think typically we've thought training. I think that's your model about training the supervisors is good then. But I think I'm going then, so you've done this thinking, and we've talked about, and I know the role of the task force, but you've got to spend some time thinking about prevention. And because you mentioned the decisions we make now, how will they affect the next generation? And I know that's critical. So as you're thinking about this and you have all this information, I want to know what can we do to prevent it. I really, are there good models? I really believe it takes a community to protect a child, just like it takes a village to raise a child. So I'm wondering what models or what your thoughts are on that.
2 suggestions. One, Rachel and Cindy already know, and that is I was on the National Academy of Science Committee to look at prevention of family violence. We identified then, and it holds up now, that a rigorous application of nurse home health visitation is the best evidence-tested model that's out there. Secondly, for troubled families with juvenile delinquents, multisystemic therapy is the best evidence-tested model out there to work with multi-problem families. Thirdly, it's basically common sense. You can now use geographic information systems to track where your cases are coming from, where the hotspots are in any one of your counties, and then all you have to do is look and say, and where are our resources? And in many communities with hotspots, you'll find that there are no community centers, there are no big brothers, big sisters, there are no faith-based organizations, that somehow we managed to put, it was one study we did for the Salvation Army. They had this wonderful aging program, and they owned the building, and they were doing great work, and it was smack dab in the middle of the fastest growing Hispanic population in the city, the average age of which was 24 years of age. Guys, you have this great building, but you're putting the wrong services into it. Yes, but we own the building, and yeah, but no one's going there. The elderly don't want to go there, and there's nothing there for the community. You have to align the services with the community. And the technology now, my colleague Dennis Culhane and John Fantuzzo have the technology now to basically sit down in real time and tell you every night which houses are about to foreclose, which houses had their heat turned off, where the hot spots for child neglect are about to pop up. So I think aligning the services that we have, I'm not a big fan of spending more money. I'm a big fan of spending the money we spend better. And we're not necessarily aligning the services with where the problems are and where the problems are growing the fastest.
Just kind of, Doctor, you mentioned two colleagues that have the ability to monitor real time. Can you mention those names again so we can?
Dennis Culhane and John Fantuzzo. John is in the Graduate School of Education. Dennis is in our school, the School of Social Policy and Practice. Their model is being used now in 10 different large cities. They get a data download from the city every night of child abuse cases, heating shutoffs, tax non-payments. It's called the Kids Data Set, and they do a lot of research off of it, but they do a lot of advising in terms of social problem solutions. Homelessness is probably one of their better and more effective programs that they're dealing with.
And when you spoke earlier during your testimony, you mentioned an opportunity per decade to overhaul, I think was the terminology used, a system like this. Is that something you're talking about, looking at those types of services? And do you suggest that we really need to look at rewriting and overhauling the CPSL?
There seem to be multiple questions in that, and I got to the last one. I'll give you my idealized view of the world. Domino's knows more about the pizza I just ordered than you know about kids in foster care. Granted, they don't have that many moving parts, and it's all within the same store. But within the Commonwealth, you have all the data on children and families you ever need. You just don't get it in the same place at the same time, such that somebody can use it in real time to make these critical decisions. So a shameless self-promotion of what the field center is doing. We've been working with Montgomery County to adopt the use of not just handheld devices, but make all the data they have available to the single endpoint user. So the endpoint user knows in real time everything that's going on with this child and this family. One step from that is to be able to aggregate all that data and then come up with a algorithm or a scale that says, knowing all of this, what's the likelihood something awful is going to happen in this family? Or what's the likelihood this family is going to engage in services? Just because they struck out with child 1, 2, and 3, common sense would say they'd strike out with child number 4, but just to make sure, let's run through where they stand to be today. Most of the time we're judging child number 4 on data that's 2 years old, 3 years old, 5 years old, or not even available. So you need to just have your law ready for that day. And again, don't make them drink from a fire hose. Keep the law and the report is restricted enough so that you get a manageable enough population of the children you want to keep safe.
This is actually my first meeting, so I betray a little bit ignorance about the subject, so bear with me. When you say, for example, in 2010, there were 24,000 instances reported of child abuse in Commonwealth, in terms of your common sense and professional instinct, what order of magnitude is that number represent in Pennsylvania, in your view? Accurate, inaccurate, wildly off?
Oh, I think the advocates in the state almost uniformly believe that it's low, that although I'm dubious that everybody reads the law, I think they've been in business long enough that they've developed a sense of what they can report and what's pointless to report. So I think that our reporting rate and our substantiation rate tend to be on the low end of what you would expect of a state that has Philadelphia in the east, Pittsburgh in the west, and rural counties in between.
The other is, when you say the overall rate of 14.9% of the reports was substantiated after an investigation, in practical terms, does that mean that the other remaining percentage were invalid, inaccurate?
Usually, screening is supposed to take out the ones, I was sexually abused when I was 12, I'm 42 now, and maybe abuser has died. That's not going.
Right.
I can't, I saw a mother hit her child in the supermarket. What's the name of the mother? I don't know. Did you get the license plate? I don't know. That's not going anywhere. So those are going to get screened out. It usually is, we haven't been able to come up with sufficient evidence and corroborating evidence to meet what we understand to be the judicial bar for forcing this family to either lose their child or accept services. So there's lots of conversations in your county agencies where legal counsel will sit down with the supervisor and caseworker and say, do we have enough here to do anything? Well, if the answer is no, then you either indicate it or you not substantiate it. The false reporting rate is tiny, 5, 6, 7%. Right. But in my testimony, I said, look, these folks have to make hard decisions, and more often than not, the data are soft. Dick Krugman, who is a well-known pediatrician in the field, always likes to tell the paradox of more children die falling off of a couch than falling out of a fourth-story window. And I'll sit and say, what does that mean? He says, well, the parents say the kid fell off the couch, and we have no other way of proving otherwise. So the case doesn't go down as a parent-inflicted fatality. Very few children show up with such overt signs of abuse, neglect, and sexual abuse that they constitute no-brainer substantiations.
That's fascinating. My final observation, since education is 16.9% under Figure 2, does it make any sense to think about maybe a higher level of literacy in regards to educational professionals relative to the subject of what constitutes abuse?
It's shocking how little time we spend educating people who will ultimately be reporters.
Exactly.
And what that does is it puts your local school systems in line to be sued, because a willful ignorance of an existing state statute is just the standard you need to be able to sue the local district. And Ben Franklin has, etched onto the walkway into my building, an ounce of prevention is worth a pound of cure. And you look around and say, I don't see why these districts are not investing in the ounce of prevention, because it's going to be more than a pound of cure, and it's going to be multi-million dollars of cost.
Right, exactly. That's a good answer. And it may be one of the things that we want to circle as we begin to sort of debrief of what we've learned from this experience, because that's a significant number and something we may be able to do something about. Thank you.
I guess can I borrow yours?
Yeah.
My microphone apparently doesn't work. So I was really struck by the statement that you made that I've thought for a long time, is that mandated reporters stop reporting when they sense that nothing is being done. And I think for doctors, we have this problem where we're mandated reporters, but we have a Hippocratic oath. And if we truly believe that we're going to hurt the patient by reporting because nothing will get done, it's really a double, you're not really sure always what to do. So my question is, given that, and I think there is something to be said for that, why do you think the substantiation rate not only has gone down in Pennsylvania, but is so variable that I think the highest county is 48%, and Allegheny County is well below 10, and we're the lowest. So how do those two hook together? Because you think if people only report, like schools, if everything doesn't get mandated, that doesn't get substantiated, they would report only the severe so that the rate would go up.
I think it's a great question, and I think that you have to accept that one of the factors that influences substantiation rate is what the agency's carrying capacity is. The workers know how many foster families are out there. They know how many beds are available in foster care. They know how many beds are available in residential care. As the system, and we've seen it over 40 years, as the system gets overwhelmed, the substantiation rate actually goes down. So you look at Child Maltreatment 210 that comes out of the federal government, and you say, how is it possible that since 2008 the number of substantiated cases of child abuse and neglect in the United States went down? During a recession, that's an impossibility. Now, you know this because you've done research on head trauma. Of course it's not a responsibility. Funding for these agencies went down. Preventive programs went down. Services went down. So the caseworkers basically did battlefield triage. And they said, we can only substantiate what we can actually handle. So we're going to substantiate at a higher level of proof and a higher level of danger than we did 5 years ago. So there's a lot of counterintuitive trends that lead to these substantiation rates. And they tell you as much about what I saw Michigan back in the 1990s. Michigan solved the whole problem. For 6 months, they stopped taking reports. Child abuse virtually went away because they focused all their energies on the kids who were in foster care because they just couldn't get kids out of the foster care system. So they decided, look, we're going to focus on foster care. And, unless the child is near death, we're not taking the report. So you can't, those data are an interesting statement about your county agencies, but they're not a statement about how much child abuse exists in the community.
Anything further? Thank you very, very much.
Thank you very much.
And we will continue with what I'm sure will be further intellectual rigor. Our next presenter is Deborah Schilling-Wolf, who is the Executive Director of the Field Center for Children's Policy, Practice, and Research at Penn.
Thank you. Mr. Chairman, members of the task force, thank you for the opportunity to appear before you today and offer testimony. My name is Deborah Schilling-Wolf. I am the Executive Director of the Field Center for Children's Policy, Practice, and Research at the University of Pennsylvania. The Field Center is an interdisciplinary collaboration of the University of Pennsylvania's Schools of Social Policy and Practice, Law, Medicine, and Nursing in the Children's Hospital of Philadelphia, bringing together experts from a variety of disciplines to advance reform in the child welfare arena. I've worked in the child welfare field for over 30 years in 7 different states, have served on national boards, and I'm a proud member of Montgomery County Office of Children and Youth Citizens Advisory Committee. I began my career investigating child abuse and neglect reports and subsequently supervising caseworkers in Massachusetts' child welfare system. My experience includes directing the New York Foundling Hospital's crisis nursery in New York City, serving as Director of Child Welfare for Catholic Social Services in Oakland County, Michigan, at the time when they were taking reports, and establishing the former Boston City Hospital's interdisciplinary child sexual abuse team, tasked with assessing alleged sexual abuse of children and providing treatment to victims and their families. My clinical work includes individual, family, and group therapy with victims of child abuse and their families in New Hampshire, Massachusetts, and Ohio. Prior to relocating to Pennsylvania, I served as clinical director of a community-based nonprofit agency in Tucson, Arizona, and piloted a public-private partnership called Family Builders, developed to provide an alternative response for child abuse and neglect reports, and heralded as one of the top 10 new innovative government programs the year it was initiated. My testimony today will cover 2 distinct areas: a national perspective based on my own professional work, and an analysis by the Field Center's team of experts with recommendations for reform. The Field Center's team, comprised of renowned faculty, fellows, and staff, each with distinct expertise in one or more aspects of child welfare, gather weekly to review research, analyze policy and laws, and address needed reform on local, state, and national levels. The disciplines of law, social policy, pediatric medicine, nursing, social work, forensic psychology, and research are all at the table. And I am honored to represent my colleagues with the following analysis and recommendations. As I am sure you've heard, Pennsylvania is a national outlier in the investigation and substantiation of child abuse. In 2009, Pennsylvania's substantiated child abuse rate was the lowest in the country at 1.4 per thousand children, compared to the national average of 9.3 per thousand. In 2010, Pennsylvania had the lowest rate in the country of children who received a CPS response. The next lowest rate was in Hawaii, who had double Pennsylvania's rate. There are many factors that contribute to this. Some of the reasons are the high bar for determining abuse, the ambiguity of the definition and perceived need to identify a perpetrator, and Pennsylvania's unique two-tiered system that excludes a significant number of cases from being counted in state data. Pennsylvania's current child abuse reporting law is flawed. We find the statute to be both confusing and widely open to interpretation. As an aside, I'm not an attorney. I really have difficulty understanding this, and I've worked in this field forever. The attorneys in our team had difficulty understanding the law. How do we expect people to abide by it or put it into practice? The law should serve as a roadmap for caseworkers to investigate reports of child abuse. Yet there are fundamental differences from county to county on how the law is applied. If a child is abused, then it shouldn't matter if he or she lives in Monroe or Montgomery County. It should be clear, and the same determination should be made. That is not happening. Pennsylvania's laws are not victim or child focused. If a child is abused, then that child should be determined to be abused. In practice, in many Pennsylvania counties, caseworkers fail to substantiate abuse if they cannot identify the perpetrator, as the current statute requires that abuse be committed by someone who falls within the statutory definition of perpetrator. This narrow definition can also prevent reports from being accepted for investigation. The very case that brought us here is a good example. One of the Field Center's law fellows analyzed the statute, and it appears that Jerry Sandusky likely failed to meet Pennsylvania's definition of a perpetrator, and therefore his alleged victims would not have fallen within the purview of the child welfare system. Just the fact that this is open to debate demonstrates the problem. In child or victim-focused laws, a determination is made much in the way a medical diagnosis is reached. If a child has chickenpox, it doesn't matter if he or she caught it from a sibling, from a friend, or a classmate. The child still has chickenpox. If a child has been determined to have been abused, then the report should be substantiated. Identification of the perpetrator should fall under the purview of the criminal justice system. That is their role. We recommend that the law be amended to no longer require a specific perpetrator in order to investigate or reach a determination of child abuse. The definition of serious physical injury in the statute creates a bar so high that it often prevents the substantiation of serious physical abuse. The statute requires the child to experience severe pain, which is a subjective and medically and developmentally inappropriate measurement. Medical research shows that there is great disparity in how children experience pain. As a result, it is very difficult to substantiate physical abuse cases in Pennsylvania in comparison to other states. There is something very wrong when a hospital makes a definitive diagnosis of child abuse, yet the child welfare system cannot substantiate the report. A caseworker in one county told me that she was unable to substantiate a case according to the current law, yet the criminal justice system was able to arrest the perpetrator nonetheless. That's crazy. We recommend a modification in the definition eliminating severe pain as a criteria and instead focusing on serious physical injury and imminent threat of serious harm to define physical abuse. In order to substantiate abuse, the child's injuries must be the result of non-accidental conduct by the perpetrator. Non-accidental, as defined in the statute, appears to intend to impose something akin to a criminal negligence standard on the perpetrator. However, the word intentional in the definition is often misinterpreted. It was meant to mean that the perpetrator's acts were not involuntary, but it is often interpreted to require the perpetrator intended to harm the child. We recommend clarifying this definition so it too was not left up to interpretation. In practice, reflects the statute's intent. Pennsylvania statute currently requires a professional who works in an institution to report suspected abuse to his or her superiors. It is then only the duty of the institution, not the professional with the first-hand knowledge, to report to Childline. We are concerned that this not only prevents the most accurate information from being conveyed, but that it also dilutes responsibility. We believe that both the individual and the institution in which he or she operates must be required to report. The rationale for this is straightforward. The person with direct knowledge is the most reliable source of information, and their account must be reported. Meanwhile, the institution must demonstrate that it is aware of the incident and produce its own report. When those with direct knowledge report to others who are charged with reporting, the allegations can take on a different form and not accurately portray the incident or become so diluted that they change from reportable to non-reportable conditions, such as in the Penn State case. Here, alleged sexual contact in the shower became horsing around when the incident was reported up internally. Horsing around is not a reportable condition. We recommend the following very specific recommendations to this provision of the law. That institutions must be required to develop procedures for reporting child abuse both internally and externally, including designating an individual within the institution to receive such reports. The individual with direct knowledge must report up the chain in his or her institution to a designated individual according to the institution's new statutorily required policy. The institution must report to Childline. Those individuals with direct knowledge must also report. However, these individuals have the option of either reporting individually or reporting in conjunction with others who also have the same direct knowledge. This will prevent, as Dr. Christian raised earlier, duplicative reports with the same information from mandated reporters who all work within the same institution and are reporting the same information, such as shift nurses in a hospital. Hospital trauma teams are excellent models of such policies. They have had these policies for many, many years. I was on them in Massachusetts. They know how to do it, and it's really wonderful, and I would really encourage you to look to those trauma teams for those sort of policies. Pennsylvania currently has a bifurcated reporting procedure with one set of rules applying to schools and another set applying to everyone else, unlike other states. Reports stemming from schools only result in GPS action, not CPS, which is a decision that we neither understand nor endorse. We see no reason for this distinction and division, and it may be counterproductive. In 2010, there were only 16 cases of substantiated school abuse across Pennsylvania. We recommend that the school reporting system be eliminated entirely and that schools and school employees be required to follow the same reporting procedures as everyone else. For several years, the Field Center has been studying jurisdictional barriers to accepting reports for investigation when the victim, perpetrator, and incident involve more than one state. Often, these cases fall through the cracks, with states refusing to accept referrals that cross state lines, resulting in no one investigating the allegations. We are recommending that the reporting law be amended to provide jurisdiction to investigate reports of child abuse when the victim, the perpetrator, or the incident happened in Pennsylvania. So at least in Pennsylvania, we can assure that children don't fall through the cracks. Excuse me. The Field Center does not recommend extending the mandate for all adults for reporting child abuse. Research shows the reports by professionals are substantiated at a significantly higher rate than those of the general public. Childline is unable to process the calls it currently receives. We need to improve both training and confidence in the child welfare system for current mandated reporters before there's any consideration to further open the gates. Many of our county agencies are at capacity. Any increase in reports must be accompanied by an increased capacity to investigate these reports and provide services for those families who are determined to need further intervention. I'm going to go off script for a minute here. We are very concerned by all of the efforts to increase reporting without an acknowledgement that these reports need to be investigated, and then if there are substantiation services need to be provided. We are going to set up the system for failure unless we look at what happens after that call comes in. So I really urge you to keep that in mind with whatever determinations you make, recommendations you make. Adding additional reports without additional resources at the county level is creating an unfunded mandate, a recipe for disaster in the current economic climate. This could easily create a situation in which more serious cases fall through the cracks, while already stretched agencies are try to meet the increased demand. However, any individual always has the option to report suspected abuse voluntarily, and that's something else that has seemed to have gone off the radar in discussions. In light of the Sandusky case, we would recommend adding additional classes of mandated reporters, such as sports coaches. In addition, we do not believe that increasing the penalty for failing to report will have the desired result of making a substantive difference in responsible reporting of suspected child abuse. Pennsylvania has a differential reporting system, not a differential response system. Currently, cases that fall outside of the narrow definition of child abuse and neglect are classified as General Protective Services, or GPS. GPS cases are not tracked and do not count in the data as child abuse reports, rendering those who are interested unable to compare Pennsylvania's data with that of other states. Again, one of the reasons for our outlying data. Of greater concern is that GPS reports are not maintained in the state's central registry, and therefore may not be available if and when a subsequent report is made on the same child and family. 2010 DPW data shows that there were 15,000 more GPS cases than CPS and school abuse combined. Yet, GPS warranted only a bullet point on page 30 of DPW's annual child abuse report. The Philadelphia Department of Human Services conducted an analysis of subsequent reports for state fiscal years 2006 and 2009 for both CPS and GPS cases. In both years, GPS reports were substantially more likely than CPS reports to have a repeat incident within 18 months. The data, using a DHS internally designed severity rating scale, suggests that a substantial number of the subsequent reports were as serious or more serious than the initial reports received on cases. GPS represents a catch-all for cases that fail to meet the high bar for CPS. For example, reports of alleged sexual abuse that fail to meet the strict criteria end up being classified as GPS cases. Ironically, many of these cases are serious enough to warrant a forensic interview at county child advocacy centers. Although GPS cases are often referred to as just neglect, they often represent some of the highest risk child welfare cases. The death of Philadelphia's Danielle Kelly is a case in point. With a history of no less than 7 different reports of neglect, at age 14, Danielle died, weighing only 46 pounds at the time of her death. She was profoundly and fatally neglected. Child neglect constitutes close to 80% of reports nationally, yet these cases are virtually ignored by Pennsylvania's child protection system. Differential response, in which child protection agencies offer both traditional investigations and alternative assessments for child abuse and neglect reports, has been implemented in other parts of the country and evaluated as to their impact and effectiveness. The Administration on Children and Families reviewed the existing research, and the Child Information Gateway published a comprehensive issue brief on differential response in 2008. As a result of differential response, a larger percentage of investigations were substantiated, as focus was on the more serious cases. Among the findings was that child safety was not compromised under differential response systems. Increased services to families lowered subsequent reports. Services could be provided to families quicker than if they were served through the traditional child protection system. Families were found to be more cooperative and willing to accept services, and differential response appeared to be cost-effective over the long term. I had the opportunity to pilot Arizona's former differential response system, Family Builders, coordinating the private sector portion of a public-private partnership designed to better meet the needs of children reported for child abuse and neglect. At the time, Arizona was not investigating all the child abuse reports. They just didn't have the capacity, and thousands of cases were going uninvestigated. This resulted in a legislative mandate for differential response. Arizona classified child abuse and neglect reports into 4 categories of severity and elected to defer the less serious reports to consortiums of community-based private agencies in lieu of a CPS investigation. So the cases came in, they were accepted as reports, what Pennsylvania is not doing, being screened, and then a decision was made whether to conduct a formal CPS investigation or defer it to the alternative response system. That gate, as Dean Gellis talked about the gates, is a critical one that Pennsylvania does not have. Consortiums of providers approached families, informing them of the CPS report and that they were being offered voluntary services in lieu of a CPS investigation. If, when in the home, the assessment team felt that the situation warranted more serious involvement, the case would be referred back to the CPS unit for investigation. Similarly, the reports of families who refused an assessment were screened for possible CPS involvement. An assessment was completed on each family that agreed, and traditional and non-traditional services were offered, focused on alleviating the cause of the report rather than just the allegations. Currently, if a CPS report is filed, we focus on what were those specific allegations and look to make a determination, can we substantiate this specific little piece that's told about this family that could have many, many issues. Differential response offers you the opportunity to look not just at that symptom, but look at the cause. For example, if it were determined that mom's drug involvement resulted in her losing control and hitting her child, she'd be referred for drug treatment. Traditional investigative services would have focused on the symptom of her drug problem, hitting her child. In one case in a rural community, 2 parents and their adolescent children, and this is Arizona, guys, were living together in a small trailer, causing great stress due to close quarters. Family builders helped the family identify supportive friends and relatives, again, helping them develop a support system for future needs. And family builders provided them building supplies they could put in addition on their trailer, addressing the cause of the problem. Each consortium was contractually required to provide a variety of services to family, including substance abuse treatment, home and office-based counseling, emergency funds, and a variety of other services. And non-traditional partners were also included. For example, we engaged Home Depot, who agreed to provide a 10% discount for building supplies. A wonderful way to engage your entire community in taking responsibility for families that are high risk. Based on published research and program evaluation, significant challenges to the current CPS-GPS structure, and the need to focus resources on the highest risk cases, I recommend that Pennsylvania adopt a differential response system in lieu of the current CPS-GPS system to better address the needs of our at-risk children. I also wish to close by acknowledging and honoring Jerry Sandusky's alleged victims who told their story and thereby caused all of us to take a hard look at how Pennsylvania is protecting its children. They're providing us with the opportunity to do better. Thank you.
Thank you. Doctor, perhaps we could start with you, Dr. Bergenstein.
Thank you very much. I really agree with virtually everything you've said and have said it before, and I think it can only be repeated never too many times. Just one question. I really like this statement you made about Arizona, about the consortiums that would approach these families, and as the families refused it, then it basically went back into the CPS system. And I see as one of the biggest problems is that if families don't reach that bar of a substantiated report, we can offer services, but if the families don't accept, basically see it as, okay, well, they don't have to because it's not substantiated, or we have no way to track whether services are completed, given, really what happens, it kind of falls off the radar. So I guess, what did you see? Did you see that this worked, and how often did families actually, sometimes I feel like you could say to the family, if you go through all your services, then we won't substantiate. I think that's potentially an acceptable alternative, but I think now what we have is a middle ground that doesn't help anybody.
Yeah, what happened in Arizona is we actually, because we approached families from a strength-based perspective, and approach families that we want to help you be the best kind of parents that you can be. The reality is most parents do want to be the best kind of parents they can be. There are a variety of reasons why they're unable to meet their children's needs. So approaching, the success of the program is really based on a strengths-based approach. And developing, again, using those engagement skills, and we really focused on the workers having excellent engagement skills to be able to engage families and being able to help them and say, we can help you with X, Y, and Z. Frequently, we had very, very good success rate in families agreeing to services. Cases, and I don't want to mislead you that if they refused, the case automatically went back to CPS for investigation. It got reviewed to see, are the allegations serious enough that we feel that we need to investigate. So most of the cases, because they had been pre-screened, the allegations themselves, were felt to be, but every case was reviewed. There was that, that catch and balance. So that's how it worked. But we were very successful, again, with the voluntary approach, made a huge difference with families.
One other very quick. People often say we have a differential system. Based on what you're saying, you would say we don't have a differential system, and the differential system you're imagining, neglect is not. It's not separation by abuse versus neglect. It's separation by risk. Is that?
Yeah, and that's really how, and Arizona, and they no longer, they have actually chosen to not continue this particular program. But currently, there are, say, approximately, depending on the last report I read was in 2009, there were allegedly 18 differential response systems. Pennsylvania was listed as one, but when they went to further research, Pennsylvania was one of 4 that was dropped. Pennsylvania does not meet the first criteria of differential response, which is that every case is accepted and screened as a CPS report. So that's really the difference.
My observation, or just a question, I guess, on page 4, when you say that the child line is unable to process the calls it currently receives, to me that's very distressing, because it indicates there's a magnitude of problems here that we're not even getting to. And it seems to me if that, in fact, is the case, and you also go on to say adding additional reports without additional resources at the county level is creating an unfunded mandate, a recipe for disaster in the current economic climate. I think that's true and needs to be highlighted. So aside from coming up with recommendations and insights as to how we can improve the system, if we don't have the capacity to carry out the improvements that we're recommending, I'm not sure exactly what the purpose of this exercise would be. So I would put a star around that so that whoever's responsible in the field of finding resources for this issue needs to get on that pretty quickly, because that suggests to me that feels like a tsunami. If I understand the intent of what you said.
Absolutely. Yes. Yes, I agree with you completely. You put it very well.
Good morning. Just as a follow-up to your Arizona system, did you say that they're not using that anymore?
Yeah, they're not. Arizona, and it was after I left, but my understanding is that there were audit issues in terms of monitoring the money that the agency, that they weren't monitoring how the money was spent in terms of sending out to the public-private partnerships. Arizona right now is in major crisis. Their system is, collapsing unto itself. In fact, Dean Gellis had an editorial in Sunday's Arizona Republic on the system. So, Arizona is not a state to say.
It's not the one we want to look at, right?
They're doing it well. There are other states that are doing it well, and there is a National Center on Quality Improvement that's focused specifically on differential response, and they have pilot projects. I think Dean Gellis referred to Florida. They have several pilots going, and they have some really promising practices. So I wanted to share my particular experience on how it could happen, but yeah, I think, and this was, 15 years ago. So, really there are other states to look at who are doing better, and I would really look at the, the national center that is, focused on excellence in this area for guidance, if you're looking in that direction.
Thank you. I would note that we will be hearing from folks associated with Childline in a subsequent hearing. Doctor?
Hello, Debbie. How are you? Thank you very much for those comments. I'd like to, just for the record, almost second or just support one of the things that you said, which is that if our lawyers have difficulty in understanding and interpreting our child welfare laws, it's really quite difficult for, other non-lawyer professionals and obviously non-professionals. But I think that's in part why lawyers write that way. The second question that I have, it always seems to me that this system spends an enormous amount of capital and money on the front end investigation portion of the system. Enormous amounts, just investigating and then really substantiating just a minority of the cases that are investigated, and then providing services to even fewer of the cases that are investigated. And do you know whether the differential response programs that other states have actually have cost savings because they're like decreasing the amount of expenses on the front end part of the system? That's my second, and then I have one final comment, and then I will move along to.
The research study shows that they are cost effective. I know in particular the program that I worked in was built on a managed care model, which was, very interesting. What they did is they paid the agency, you got paid for every referral you received, a flat amount of money, small amount. Every assessment you completed, you got paid for, and every family that accepted and received services, you got another pot of money. That pot of money had to pay for all of the services, and you aggregated that over your agency. So it was, you weren't paying for services, the state wasn't paying for services that weren't being provided, and it ended up being a very cost-efficient, very creative way to do things. But the research shows that they are more cost-effective. And if you just look at the fact that they're reducing families coming back into the system, from a money perspective alone, that's valuable.
Thank you. And then my last comment, I don't know if this is rhetoric, but I've always found this kind of the intentionality of part of the definition of child abuse to be really quite difficult, because at the end of the day, in many of the cases, sometimes of some of the most severe physical abuse that I see, it's hard to know what somebody's intent really is and really was. But I do note that we have not one, not two, but 3 lawyers coming up. So maybe they can comment on on kind of the intentionality portion of the statute, which
and they better than I
is difficult.
Thank you, Mr. Chair. Just to try to get my hands around this, and thank you for your comments and presentation. Addressing penalty, I believe you said that you do not believe that increased penalties would equate to increased reporting or increased child safety necessarily.
Yes.
And so my question is, when you talk about increased penalty, are you speaking in the scope of the criminal justice system, or considering other types of penalties like impact on licensure or impact on institutions to require training for failure to report or something like that?
I was speaking merely to, for example, making it a felony for a mandated reporter to not report child abuse. I don't believe that would be a motivator to change someone's behavior, or we don't as a team.
If we were someone was to identify failure to report, and perhaps the requirement would be to do some remedial training or institutional-wide training, that's not what you were addressing.
Yeah, no, I was talking about criminal sanctions, increased criminal sanctions. Yeah.
The other question I had, and we've talked as a task force and the general public about the definition of child abuse. And I haven't heard anybody say we have a great definition here in the Commonwealth. But you commented on removal of the portion that deals with the child who experiences severe pain. Are you suggesting we should remove that completely or add to it with additional terms?
Remove it completely. Pain is, and research has shown that pain is subjective, that different people experience and children experience pain differently. So that if you're using that as a measurement of a child's been abused, then a child could have, two kids could have the same abuse inflicted on them. One would be considered abuse and one not. Developmentally, for preverbal special needs children who are not able to express that, if you can't have something that can't be applied uniformly to everyone, it does not make sense. And other states do not have a pain threshold for abuse. The definitions are much simpler. One example is the Massachusetts statute is very clear. There's no reference to a perpetrator for abuse. I used that law, and I, to this day, remember, Massachusetts General Laws, Chapter 119, sections. Then it was 51A through G. Now I think it's up to K. I remember that statute, and when I went out to investigate, I knew exactly what that statute said, and I used that as the barometer on whether to substantiate a case. I couldn't use the current statute to do that and do that. It isn't user-friendly to put it in those terms for the people who really have to use it.
For the scenario where the report occurs after an injury has appeared to have healed, and I think about significant bruising, and that comes before the authorities, doesn't the verbal child's statement of what occurred and what it felt like, shouldn't that be considered where there's no objective evidence?
Oh, absolutely, absolutely. But using, when you make a diagnosis or a determination of abuse, you look at many different factors, and that would certainly be one that would be part of it, but the pain itself should not be the sole threshold to determine whether a child's been abused. And that is really what the current statute says.
Thank you.
Good morning. I'm sorry, Mr. Chairman. Okay, thank you. I've heard this come up with some other presenters, and I guess I'm trying to figure out in my own mind the impact of it. Folks say that they would not like to see an increase in the people who are going to be mandated reporters, but then they propose eliminating a definition of perpetrator, which would actually also impact on the caseload that Children, Youth, and Family Services would be investigating, because right now the goal in Pennsylvania is to look at families that are in crisis and provide services to families in crisis. If you remove the perpetrator designation from CYS in their initial determination, you're going to be opening them up to investigating all cases involving children. And I guess I think that's inconsistent with the same statement that folks are making about not wanting to increase mandated reporters, because actually reporting the act of abuse with the phone calls to Childline, you would think would be a lot less work than opening up Children, Youth, and Families to investigating all cases involving abuse of children, where right now they're limited to certain cases involving family members or people who take on the role of supervising the children. So I guess, am I missing something with that? Or
you're asking an excellent question. What it speaks to is what cases, the type of cases, and how they're being responded. Our concern about opening up cases to, the floodgates with non-mandated reporters is that research shows that we will be increasing many, many cases that will not be substantiated, cases, the reports that don't make that standard. So you are having resources focused on cases that don't necessarily need services. If we look at removing the perpetrator, for example, in practicality, we're really only talking about sexual abuse cases. If we look at neglect, it's really neglect by the caretaker. the neighbor down the street can't be neglecting a child. It's the person who's responsible for their care. So that won't impact those numbers. Physical abuse as well, you know, it's a caretaker or parent, so you're not increasing those numbers. So it really is only focusing on the sexual abuse cases. And my understanding is that you'll be hearing next from multidisciplinary teams and child advocacy centers as a subsequent hearing. That approach to investigation addresses some of your concerns. One of the things the Field Center was fortunate to do was help Montgomery County establish their child advocacy center, Mission Kids. And what they do, as the other CACs do, is they have at the table the child welfare system, law enforcement, district attorney, other stakeholders, and they staff cases together so that the current law enforcement only cases get staffed with the child welfare workers. And together they look at all of the cases and decide who is best to do what. So it's not necessarily increasing, I mean there will be some increase, but it's not necessarily opening up the floodgates in that end, but it's refining who is doing what so kids can get services better. I'd like to share one example of a case that really concerned me and led me to think that the child welfare system really should be at the table for all cases of sexual abuse of children. An adolescent girl was brought to an emergency room after being raped. The victim service worker was called, and she came from the local victim services agency. The child advocacy, and the family is being referred to the Child Advocacy Center for a forensic interview. And the victim service worker said, "You don't have to talk to them if you don't want it. You're right not to talk to them." So this girl then didn't trust this entire team of folks who were there to help support her through the process. A team approach avoids that problem. It really makes sure that the victim gets the services. And if out of everything I said today about the statute, if the one idea I can really drum home to you is that the child abuse statute in Pennsylvania is not written from the perspective of the victim. It has the marks of every stakeholder who wanted their hands to protect their territory or what they felt was important in there. Parents' rights folks, the school department, and that's what it looks like. In reality, the children lose.
I would agree with that. I think that has been borne out even more so over the weeks that we've had some testimony about the fact that our system is not child-centered. But I guess even with your explanation about the multidisciplinary approach to child abuse cases, that's assuming that every county is going to have a child advocacy center up and running. And I think that Blair County is pretty well advanced, but we're a smaller county. We're a fifth-class county. We don't have currently a child advocacy center that isn't 2.5 hours away. So when I hear everyone saying they would like to see it be multidisciplinary for every case involving child abuse, my concern is not only from resource standpoint of Children, Youth, and Family Services, but resource standpoint and where we are in terms of cooperating with each other on every case and the magnitude of those types of changes. One quick
Could I just
Sure.
respond to one thing with that? It's my understanding that counties are required to provide a multidisciplinary team. And so even if you do not have a CAC in your particular county, and it really is a luxury. I mean, it's something that we would like to see in many places, but it's a luxury particularly, and working in a state with large rural pockets, we certainly understand. I think that was one of the downfalls of their system. But just the fact of being able to have that multidisciplinary, which is required, approach will address some of the concerns without having to have a formal CAC.
Well, and there are issues from I'm a prosecutor, so I come from it from a law enforcement standpoint. Some of the concerns that we would have are things related to an investigation where we already have issues where children and youth caseworkers are interviewing perpetrators at the jail before the police can get there, and then we have Miranda issues, we have admissibility issues. So it opens up a huge amount of other matters that we would need to consider, I think, as members of the task force. But one quick thing I want to point out, and I may be totally incorrect about this, is that my understanding of the current state of law in Pennsylvania is as it relates to the reports of school employees about abuse that is occurring. If that person is otherwise a mandated reporter and they're reporting abuse relating to a child not committed by a school employee, it is my understanding that they can call Childline themselves. They have that obligation under the Mandatory Reporting Act. If the actual person who's committing the abuse is a school employee, then the law says they need to report it to their administrator, who then reports it to the district attorney and law enforcement, and those cases